I'm Laura Maltby, and today we're discussing commercial property leases. Whether you're a landlord or a tenant, understanding the terms and legal implications of a commercial lease is crucial. So, let's break it down. A commercial property lease is a legally binding contract between a landlord and a tenant for the rental of business premises. It outlines the terms and conditions under which the tenant can occupy and use the property. So, let's start with the basics of a commercial lease agreement. Here are the key components of any commercial lease. 1. The parties involved, the names of the landlord and the tenant. 2. Property description, a detailed description of the leased property which should include a plan showing the property being leased, edge red, and should show any common areas which are to be shared with other users of the building. 3. Lease term, the duration of the lease agreement. 4. Rent and payment terms, amount of rent and payment schedule and any provision for rent review at certain points during the lease. 5. Use of the property, the permitted use of the property by the tenant. 6. Maintenance and repairs, responsibilities for maintenance and repairs. 7. Insurance, insurance requirements for both parties. 8. Termination, the conditions under which the leases can be terminated. Now, let's dive into each of these components in more detail. First, the parties involved. The lease must clearly identify the landlord and the tenant, including their legal names and contact details. If the tenant is to be a company, then the landlord will normally require at least one director to stand as guarantor under the lease. The guarantor should be a party to that lease. Next, the property description. This should include a detailed description of the premises, including the address, the size, and any included facilities or amenities. The description will usually refer to a plan, where the extent of the premises should be edge red. The lease term. This specifies the duration of the lease, which can range from a few months to several years. It's very important to agree on the term that suits both parties' needs. The tenant should be aware that the length of the term may have an impact on the amount of stamp duty payable, depending on the amount of rent being paid. Rent and payment terms. These must clearly be outlined, including the amount of rent, the due dates, and any provisions for rent reviews or increases, including when such rent reviews will take place and on what basis the rent will be reviewed and the new rent calculated. The use of the property. This section defines what activities a tenant is allowed to conduct on the premises. It's crucial to ensure that the intended use complies with local planning regulations. Just because a particular use is permitted in the lease does not mean it's permitted under planning law. Further, how the use is defined in the definitions section of the lease can have an impact on the rent review, and so it's very important to take legal advice on this at an early stage. Maintenance and repairs. This deals with the responsibilities of the landlord and the tenant. Unless expressly agreed otherwise, most leases are fully repairing and insuring leases. This means that the tenant is responsible for the cost of the repairs and upkeep of the property, and also the cost of the building's insurance, which the landlord will nearly always arrange themselves. If the tenant occupies only part of the building, these costs are usually shared with other tenants. If the tenant does not wish to be responsible for all of the repairs in the building, they will need to agree an amendment to the lease and their obligations at the time the lease is drafted. There are several ways to do this, and advice should be sought from a solicitor. Insurance. Insurance requirements include the types of insurance each party must carry, such as property insurance for the landlord and public liability insurance for the tenant. Commercial buildings insurance will usually look at the risks that need insuring against, which your lease should detail, and to which you and your landlord agree. It often also includes for the landlord 3 years loss of rent, and covers risks such as fire and theft. Usually, the landlord will arrange and pay for the insurance, and you will need to reimburse the landlord either the full premium or, if you have a lease of part, just a proportion for the area that you occupy. Termination. Termination clauses specify the conditions under which the lease can be ended early by either party. This may include a break clause, forfeiture, or mutual agreement. If there is no termination clause agreed, the landlord may allow you to end the lease early, subject to payment of a premium. But note, there is no legal obligation on the landlord to allow you to end the lease. Therefore, it's very important that you think about whether or not you may require a break clause in your lease at the time that your lease is agreed. Understanding your rights and obligations under a commercial lease is essential for both landlords and tenants. So let's explore some best practice to ensure a smooth leasing experience. So, best practice for commercial leases. Firstly, seek legal advice. Always consult a solicitor before signing a lease. In reality, it is best to instruct a solicitor at the point the initial terms are agreed and before a first draft lease is issued by the landlord or their solicitor. 2. Negotiate the terms. Ensure that the lease terms are fair and reasonable and reflect your business needs and future requirements. 3. Understand your obligations. Understand your responsibilities for maintenance, repairs, and insurance. 4. Budget for costs. Be aware all of the costs, including rent, service charges, and rates. 5. Plan for the future. Consider the long-term implications such as lease renewals and break clauses. Think about where your business might be in 5 years' time. So, let's take a closer look at what each of these best practices. So, firstly, seek legal advice. A solicitor can help you understand the lease terms and ensure your interests are protected. Never sign a lease without professional advice. You should ideally instruct a solicitor at the time that the lease terms are first negotiated, so you can get the best possible terms for you. It can be awkward trying to amend the agreed terms once the draft lease has been issued, and the landlord may be less agreeable to doing so. Negotiate terms. Don't hesitate to negotiate the lease terms. Ensure they are fair and align with your business needs and your financial capabilities. Again, do seek advice on the terms so that you fully understand what you are negotiating. Understand your obligations. Clearly understand your obligations regarding maintenance, repairs, and insurance to avoid any disputes down the line. In the same way as you would for a house purchase, we strongly recommend that you instruct a surveyor to survey the property so that any upcoming maintenance issues can be discussed between you and the landlord and agreement can be reached as to who is responsible. It may be that you can agree that certain defects will not actually be your responsibility. Budget for costs. Be aware of all the associated costs, including rent, service charges, business rates, and any additional fees outlined in the lease. If there are provisions for rent review, take into account how much the rent could potentially increase by. Plan for the future. Consider the long-term implications of the lease, such as options for renewal, potential rent increases, and break clauses that might allow you to terminate the lease. Think about where you see your business in 5 years' time. To recap, commercial property leases are complex legal documents that require careful consideration and understanding. By following these guidelines and by instructing a solicitor early, you are more likely to have a successful and smooth leasing experience. We hope this video has provided valuable insight into commercial property leases. For expert help and advice on your commercial property transactions, please get in touch with us at Stark Roy Solicitors and we would be very happy to help.